following landlord and tenant educational models were developed as a community service in partnership between the City of Hutchinson, the United Way of Reno County, and the Housing and Credit Counseling, Inc. of Topeka, Kansas. A series of 8 educational models were developed and produced by HCCI to identify and address frequently raised landlord and tenant issues in the Hutchinson area. Topics included in the 8 educational models include topic of leases, security deposits, notices, evictions, move-in, move-out inspections, renters' rights, abandonment, and pets, companion animals, and service animals. All information discussed in the landlord-tenant educational models can be referenced in the Kansas Residential Landlord and Tenant Act, or the KRLTA. Module 8, Pets, Service, Companion, and Therapy Animals. When you talk about this subject of pets, service, companion, and therapy animals, there's several governing laws that one must consider. We start with KSA 582550, which is the Kansas Residential Landlord and Tenant Act. Then there is the Federal Fair Housing Act of 1988. Then there is a Section 504 of the Rehabilitation Act of 1973. And lastly, Title II of the Americans with Disabilities Act of 1990. These 4 acts are the governing laws pertaining to pets, services, companion, and therapy animals. There's also various other laws and codes that kick in when you're talking about this subject. In Hutchinson, one must consider the International Property Maintenance Code, which was adopted by reference by the Hutchinson City Council. And then Chapter 3 of the Hutchinson City Code, which establishes the Human Relations Commission and addresses discrimination in housing, employment, and public accommodation. For more information on these 2 subjects, you can go to the Hutchinson City Code, and that is available at www.hutchgov.com. When you talk about rental housing and individuals who have animals or pets, you really have to look at what it is that you're talking about, the considerations in rental housing. Are we talking about pets? Are we talking about service animals? Are we talking about therapy animals? Are we talking about companion animals? One cannot just look at an animal and make the conclusion. You have to figure out what it is that you're talking about before you take any action on both sides, both from the landlord and the tenant side. There's certain responsibilities to both sides. What happens when we're talking about animals in the rental housing situation? Individuals often misuse labels. Individuals often do not know how to label a tenant's animal and consequently mislabel animals based on the visual, what it is that they're seeing. Is it a pet? Is it a service animal? Is it a companion animal? Is it a therapy animal? How is one supposed to tell what kind of animal it is? It all starts with understanding the difference and the differences between the animals and their purpose. Pets are one thing. Service animals are trained animals and provide a service. Companion animals are just that. They do companionship. Therapy animals have a function all to their own. Let's talk about rental housing laws and service support animals. Determining the rights of a tenant in the face of a no pets policy requires a determination of what law applies to the specific situation. If I'm a landlord and I have a no pet policy, does that mean no animals of any kind can be in the apartments? you have to determine what laws will apply. Generally speaking, when we're speaking about pets, under Kansas law KSA 582550, landlords may allow pets. They don't have to, but they may allow pets, and as a result, they may charge a pet deposit. And under KSA 582550, if the rental agreement does permit the tenant to keep or maintain a pet, the landlord may demand and receive an additional security deposit not to exceed 1/2 of 1 month's rent. This is a pet deposit. It's not a per pet deposit. It's a pet deposit, period. If you have 1 animal, 2 animals, 3 animals, there's a pet deposit. Now, let's talk about exemptions to pets and pet deposit and pet policies. Exemptions to KSA 582550, Kansas Residential Landlord Tenant Act. Service animals, therapy animals, companion animals are not considered pets. And because they're not considered pets, they are therefore exempt from security deposits as defined in the statute. Animals as non-pets are eligible for deposit waivers. If I'm a tenant, I just cannot have a pet and say, this is not a pet, this is my companion animal. I just can't make that up. As a tenant, I have to have a letter, a prescription from an appropriate professional, and that could be a doctor, a therapist, or someone who is treating me, to say that my animal is exempt from requisite pet deposits. This is included in the Federal Fair Housing Act of 1988, Section 504 of the Rehabilitation Act of 73, and Title II of the ATA Act of 1990. All of these laws, the one I just mentioned, have references to service animals and various other animals. Service animals are covered by the Americans with Disabilities Act, or the ADA of 1990. Service animals provisions are also included in the Fair Housing Act of 1988 in respect to residential housing situations. For individuals who travel a lot, there is a law which covers this aspect of animals as well. Under the Air Carrier Access Act, the ACAA, it does cover service animal provisions for airline travel. What you'll find is the definition for service animal differs under each of the respective laws. Under the Americans with Disabilities Act, the definition of service animal does not limit housing providers' obligations to grant reasonable accommodation requests for assistance animals in housing under either the Fair Housing or Section 504. Under various other laws, like housing and urban development policies and laws, there are 3 sets of regulations that have been issued regarding housing and pets or assistance animals by HUD, Housing and Urban Development. Number 1, a handicapped person is almost in any dwelling is eligible for these types of animals. 2, persons in projects for the elderly or persons with disabilities under federally administered and subsidized housing programs are eligible for these animals. And persons with disabilities in public housing may be eligible as well. Other departments, such as the Department of Justice, have public accommodation language, and these regulations are issued by the Department of Justice and apply to places which include inns, hotels, motels, and other places of lodging, including single-room occupancy hotels where renters may rent for a short time. That could be a week, a month, etc. Service animals. A service animal is an animal, usually it's a dog, that is individually trained to do work or perform tasks for the benefit of an individual with a disability, including a physical disability, sensory disability, psychiatric disability, intellectual or other mental disabilities. Determining what is a service animal. As a member of the public or a business owner or a organization or any other kind of entity that does public business, what questions can I ask to determine what is a service animal? So basically, you can ask two questions. Is this animal required because of a disability? What work or task has this animal been trained to perform? Those are the two questions that public entities or private business may ask. Service animal tasks. The work or task performed by a service animal must be directly related to the individual's disability. Examples of work or tasks include, but are not limited to, 1. Assisting individuals who are blind or have low vision and navigation capabilities. 2. Alerting individuals who are deaf or hard of hearing to the presence of people or sounds. 3. Providing nonviolent protection or rescue work. 4. Pulling a wheelchair. Or 5. Assisting an individual during a seizure. Service animals are usually dogs. So a service dog must be individually trained to perform work or tasks directly related to the handler's disability. There's various categories where service dogs are defined. The following service dog categories include 1. A service dog which assists an individual who has a mobility impairment with tasks including but not limited to providing balance stability, retrieving items, and pulling wheelchairs. Another service dog category number 2 is a guide dog, which assists an individual who is blind or visually impaired with tasks such as but not limited to aiding in navigation and alerting the individual to dangers such as moving cars. 3. A hearing dog. And hearing dogs assist individuals who are deaf and hearing impaired by alerting the individual to the presence of sounds or people. 4. Alert and response dogs, and they alert an individual to a seizure or other medical condition. 5. Psychiatric service dog, which aids an individual with a cognitive, psychiatric, or neurological disability. You must note the various categories. Therapy dog is not listed. Emotional support dogs and companion dogs are not listed. And they are not listed because they are not service dogs and are considered under the ADA. Companion animal. It's a little different from a service dog or a service animal. Companion animals are virtually undistinguishable from the family pet due to the fact that companion animals may or may not be as well behaved as trained service dogs. Note that in contrast, service animals are really not trained to behave flawlessly in public like their counterparts, the service dogs. Companion animals are not individually trained to perform any specific kind of task. Companion animals' principal service is simply that, animals that provide companionship. Emotional support animals in housing, or otherwise known as ESAs. These are animals whose sole function is to provide emotional support, comfort, therapy, companionship, therapeutic benefits, or promote emotional well-being. ESA, or emotional support animals, are not service animals. You got to understand that ESAs are not service animals. They are not trained animals. Emotional support animals, or ESA, federal departments recognize, particularly in the context of residential settings and employment, where there may be compelling reason to permit the use of animals whose presence provides emotional support to a person with a disability. Accordingly, other federal agency regulations governing this situation may appropriately provide for increased access for animals other than service animals, to include emotional support animals. Another type of animal that is contained in federal law are therapy animals. Therapy animals, too, are not emotional support animals. So again, we have a different understanding and definition between an ESA, or emotional support animal, and a therapy animal. Therapy animals are working animals, and they're usually owned by a non-disabled person. Therapy animals. Therapy animals are used to visit hospitals, schools, nursing homes, a variety of different kind of sites, but they're used to help brighten the spirits of individuals in those places. Under U.S. federal law, therapy animals do not have rights under the ADA or FHA, and these laws do not apply to therapy animals. Therapy animals cannot go into places or business where no pets are allowed. Summary. The definition of service animal contained in ADA regulations does not limit housing providers' obligation to grant reasonable accommodation requests for assistant animals in housing under either the Fair Housing Act or Section 504. Basically, this is saying that just because it's not contained in the ADA does not mean that it may not be contained in fair housing or Section 504. They may be applicable. You need to understand the differences between the various laws. Conclusion. Under these laws, rules, policies, or practices, they all must be modified to permit the use of an assistant animal as a reasonable accommodation in housing when its use may be necessary to afford a person with a disability an equal opportunity to use and enjoy a dwelling and/or the common areas of a dwelling, or may be necessary to allow a qualified individual with a disability to participate in or benefit from any housing program or activity receiving financial assistance from the Housing and Urban Development, otherwise known as HUD. Where to file complaints. If you feel your rights are being violated because of your service animal, your companion animal, your emotional support animal, or other animal you may have that are protected under the federal law, you may file with these three entities. First one is under HUD, or Housing or Urban Development.gov, HUD.gov, and there's a complaint process listed. Another avenue for you is the Kansas Human Rights Commission. Again, the website is contained herein. The final one we would refer you to is the Kansas Housing Resource Corporation. These three entities here in Kansas will have complaint procedures for you to file if you feel your rights are being violated in your housing situation. Landlords and tenants have rights and responsibilities. It's not one or the other. Landlords versus tenants, both have to get together, figure out the best solution to any issue or problem regarding housing issues and situations. So we encourage you to keep communication lines open and work toward resolution using the tools available to you. To learn more about HCCI and HCCI's services, including landlord and tenant information, publications and forms, or if you need to speak to a landlord-tenant counselor, please call 785-234-0217 or go to www.hcci-ks.org.